quick, I'd love to hear your thoughts, the insider tips on when Simpson was asked to put on the gloves.
When Chris Darden was trying the case, when I was in the courtroom, he sat next to me. He would give me a slip of paper after each argument, cross-examination, whatever he did, and ask me for a score and suggest a straight A. And I usually handed him back a C minus, and his face would be unhappy. But in any event, I learned he was a hothead. The glove was sitting on the evidence table. I looked at it. I said, my Lord, that won't fit, OJ. I tried it on. I've got a size 9 hand, Exhibit A. OJ can wrap his finger around a football so he never fumbled because his hands are huge. I went over to Darden on my own during a recess, and I said, and your listeners will pardon me for quoting the exact words, but I put them in the book too. I said, Chris, you're a good shit, but you've got the balls of a stud field mouse. And he went, and I said, Chris, that glove won't fit, OJ. You don't ask him to try it on. I will. Wasn't even my witness. I was bluffing. He took the bait as Judge Ito came back to the courtroom, went up his little steps so he could get on the bench. Darden rushed him, and he said, Your Honor, Mr. Bailey has told me something, and I want Simpson to try on the glove. The rest is history. It is one of the biggest blunders ever. But at the end of the day, that didn't sell the jury, although it certainly didn't hurt.
A lot of you don't know that Lee was a fighter pilot in the Marines. And thank you for your service, sir. I really appreciate that. In 1954, he defended a gentleman named Sam Sheppard. Now, a lot of you may not know Mr. Sheppard, but you know the television show and the movie The Fugitive. The movie The Fugitive was with Mr. Harrison Ford. That movie, that television show was premised on Mr. Bailey's client, Sam Sheppard. Mr. Bailey also...
Please, Mitch, before you go any further, he was tried in 1954. I was a young fighter pilot then. I wasn't a lawyer. I took his case 7 years later, then got him out, went to the Supreme Court, got acquitted. But the case was originally lost by a labor lawyer named Bill Corrigan.
And you argued that case in front of the United States Supreme Court and had it retrial. The jury came back and acquitted your client. So job well done. A couple of other high-profile cases I just want to briefly go through is you also had involvement with representing the Boston Strangler. You also represented Patty Hearst in the armed bank robberies. A lot of us know that as the Symbionese Liberation Army case, but most of us know you from your representation of O.J. Simpson in the O.J. Simpson criminal trial. And Lee, I was a young trial lawyer back then, and I still remember your cross-examination of Detective Mark Furman when you walked up to him during cross-examination and said something like, Marine to Marine, let's talk about the N-word. You've never used it, and you got him to admit under oath that he'd never used the N-word before. And a lot of people attribute your cross-examination of Mr. Furman as being the defining factor in that case and resulting in the outcome of that case. The thing that Lee and I have learned over the years is the older we get, the wiser we get, and the more value we can share with young entrepreneurs and business owners. And that's one reason Lee agreed to be on today's case. So, Lee, thanks for being on the show. I appreciate it.
I'm happy to do it, and I want to recall the words of my German grandfather because they echo your own. We get too soon old and too late smart.
And what does that mean?
We get old before we wise up.
Yeah,
so,
yeah, amen.
We're both getting smarter.
I think the first question I'd like to ask you is, looking back in your life, based upon your life experiences, if you were starting your law firm today, or if you were starting a business today, what would be the advice that you would give yourself?
Well, it'd be totally different because the career that I have had cannot be replicated. Too many things have changed. If I were starting a law firm today, I would have one branch of very tough, able trial lawyers who happen to be ladies and gentlemen, despite that title. And I would have another branch of lawyers who keep people out of trouble before they step into it, because to me, that is the greatest service a lawyer can render for a client.
I've always said, Lee, that about 99% of the clients that sit across my desk, had they made a different decision on day one, we wouldn't be in the position that we're in. In other words, preventing legal problems from happening in the first place. It's interesting to hear you say that. Looking back at your career and looking back at the cases I've mentioned, or maybe some other cases that a lot of us aren't aware of, what's been the most gratifying or rewarding case that you've handled or been a part of as a lawyer during your career? Can you share your thoughts with us?
Yeah, because there are two cases that stand out above the rest. Some of the ones you mentioned were no fun, they were miserable. O.J. Simpson, for instance, I got most of the blame from his acquittal. And the white Anglo-Saxon community has not yet forgiven me, although I did make it from first base to second when OJ testified the other day at his own parole hearing. The public got their first look at this guy and began to say, he doesn't sound like a killer. But the two big cases were Dr. Sam Sheppard. I found him at the bottom of a barrel. He'd lost 11 appeals. I went on to lose number 12. And then I got upset. I thought, the state of Ohio knows this guy didn't do it. They want to keep him in. And so I decided to do what the Marines teach people to do, kick their ass. And we did. We got him out. We showed that he was not guilty later with DNA. Unfortunately, he was dead. And we sued the people that took credit for putting him in. The other case is not pleasant. It is one of the worst atrocities which the United States ever had to sign on to. It was called the Massacre at My Lai 4, where some U.S. soldiers, starting with a second lieutenant named Rusty Calley, marched into a village expecting the enemy, and they didn't find the enemy, so they shot everybody that was left. Women, babies, infants, elderly. They killed over 100 people whose names are not known because the Army covered it up for a while until some photographs taken by a guy on the scene named Ron Haberly showed up in Life magazine. Then all hell broke loose, and they indicted Medina, Kelly, and Medina's supervisor, a colonel. I was hired to defend Captain Medina. And in all this ugliness, which it was, I'm proud to say that's the best I've ever seen the court system function. The prosecution did their job vigorously, but ethically. I had two great Army lawyers assigned to me. We put on a wonderful case. The judge was a man to be admired for all eternity. You seldom see all those good things come together. So, Captain Medina, Dr. Sam Sheppard, they're the pinnacle, but there are others not that far behind.
Can you share with our listeners the mind of a criminal defense attorney? In other words, you're sitting across a desk from somebody that's been accused of doing, let's just assume, some bad things. Share with everyone why you decided to be a criminal defense attorney and how you sleep at night when you're representing somebody that's being accused of the things that you just described.
Well, I became a criminal defense attorney as a result of two major accidental events. I was a Marine fighter pilot soaring around the skies, burning up government fuel, which then cost 9 cents a gallon in 1952, and having a ball. I was cruising at 22,000 feet when the news came over the airways that Dr. Sam Sheppard had been charged with or was suspected of his wife's murder. A week thereafter, we had planes blowing up on takeoff. We lost a bunch of people, including the second assistant legal officer. The first assistant's wife said, "It's those wings or me." but you can't keep both. So he resigned. The commanding officer called me in. He said, "You're my new legal officer." I said, "You got to be kidding. I haven't finished college yet. I don't do law." And he said, "You will now. You have been selected as a volunteer. How's that? Your name begins BA. In the Marine Corps, we're very alphabetical." I said, "Wait a minute, Colonel. Couldn't I get an opening over in OBGYN or something more interesting?" "No, you do law." So I did. I got in the courtroom and I said, "Holy mackerel, this smells like home." I couldn't wait to get out of the Marine Corps, go to law school, ceremonial. Can't learn about trying cases in law school. So I went to court every day. I was the valedictorian of the class, but I had the worst attendance record in the history of the school, and I'm proud of both to this day because I'm a trial lawyer. I'm right out of law school. I get a call in the middle of a first-degree murder case, which was capital. "Could you come in and try to save this case?" Defense just made a horrible mistake. They invited lie detector evidence. We can't find anyone in the country that knows anything about it but you. I said, "I'm 28 years old. I haven't been practicing for 3 months. Are you sure?" "So we don't have any choice. Please come over." So I did. Defendant got acquitted. After that, I went on to be a great personal injury lawyer. Guess what? Nobody brought me injury cases. They said, "Well, Lee wouldn't take a crummy little broken leg case. He's a criminal lawyer." Little did anybody know that without the civil end of the practice, you and I would not have practiced criminal law. Now, to answer the question head on, I am quite different than many, many criminal defense lawyers in my view of the world. I honor the Constitution, the Bill of Rights. I believe that people should have the right to a presumption of innocence, burden of proof on the government, the right to remain silent and not testify, and the right to be freed if proof beyond a reasonable doubt does not get produced. At the same time, I believe that a person who is innocent, and my affiliation with the polygraph caused me to get a whole bunch of those. Problem is, innocent people are lovely, don't have any money. So you go in and slug on the cheap, so to speak. Nonetheless, I believe an innocent person is absolutely entitled to an acquittal. That is not the view of the U.S. Supreme Court. It is in great part the view of the military. And that's why I say to all of your viewers, if you are innocent of a crime and have a choice, be tried by a military court because they will acquit you. A jury, flip a coin.
Interesting. It's a similar answer that I give Lee, and that is, I do believe in our Constitution, and it's a good criminal defense attorney's job. And that's not what I do, but my friends that are very good criminal defense attorneys, they make the prosecution prove their case. They make sure the prosecution follows the Constitution, follows the due process laws, right? You don't roll over just because somebody's pointing a finger at you. And I think that's what I hear you saying. What's been your keys to success over the years in court? What have you done differently than other trial lawyers over the years that's allowed you to have the success that you've had?
I learned a bunch of this on my own, but the day after I took the bar, I had the great honor to have lunch with the kingpin of the criminal law of that era. His name was Edward Bennett Williams. He was my hero, my mentor. He defended all the big cases back in the 50s. And I said, "Mr. Williams, it looks to me like every now and then you pull a rabbit out of a hat in a courtroom and just stun everybody."
And there are some lawyers like that, aren't there?
Well, they seem to be.
Yeah.
But aligning to that silver cloud is, he said, you bring 50 hats, 50 rabbits, and you get very, very lucky. That's how you pull a rabbit out of a hat. And you've been practicing long enough to know that's exactly right.
Well, you're talking rabbits and hats, and what I'm hearing you say is you better be prepared for anything.
Preparation for more than you can encounter is the only safe road. A lot of work. A lot of people don't want to do it. If you come to my seminar, you either leave bloody or as a disciple.
Somebody that noticed that you were coming on yesterday reached out to me, and they made a comment, and I wasn't aware of this, and they said that either you don't use notes when you were trying cases, or you rarely referred to your notes. I don't use notes when I'm giving my opening or my closing. I leave it on the lectern. You either know your case by then or you don't. But is that something that you practiced while you were a criminal defense attorney, or is that just hype and it's not true?
No, no, that has much deeper roots, although it is true. I have never used a note in any court case, in any phase of it. I've also given 6,000 speeches without ever using a note. When I was very young, I was lazy. I got thrown out of school twice for cheating because I wrote the answers in the answer column with no calculations on the paper. And the teacher said, well, it must be cheating, go home. My mother, who was a woman not to be lightly dealt with, came down to school and said, I happen to have a degree in education. Who did he cheat from? He got 100. What's the next highest score? 78. Who did he copy from?
Right.
And
right.
so my life evolved. I have never used notes. I figure if you can put something in your memory, which is a course that I love to teach, two things happen. You can't leave it at home like your American Express card. You can memorize that too. And nobody else can look at the pages. So your girlfriend's phone number is secure.
I'll tell you what, I don't have the same type. Do you have a photographic memory?
No, I don't think there's any such thing. I've got a very highly trained memory. The price of doing that is that all the trivia that flows in tends to stick. I'm very good in Jeopardy, provided the question goes back at least 10, 15 years. I mean, I don't know the latest rock bands or all the hip hop that's going on, but I can sure tell you who won the Battle of Guadalcanal and how they won it.
One of my favorite things about before we went live, I shared with Lee that I was the first person in my family to go to law school, go to college in my immediate family. And I love what I'm doing. I love helping people and trying cases. One of the things I like, Lee, is every single case is different. On one case, you might have to learn about how a light works. On the next case, you may have to learn about how a jet engine works. They're all different. And to me, that's really, really fascinating. That's what gets me out of bed in the morning, because I like learning new things and then helping people in court to prove their case. With you, Lee, when you're trying a case, what's the favorite thing that you enjoy most when you are trying cases? Is there one thing that jumps out at you? The unexpected, the holding the wrongdoer accountable, making sure your innocent client's not found guilty. What's that one thing that resonated in every single case?
Well, to put it figuratively, and I'd be glad to explain how this happens, the greatest thrill in cross-examination, which properly done is the highlight of most important litigation, is to see a lying adverse witness on the witness stand and drop his trousers in front of the whole jury. Because if hard enough and fast enough, that's exactly what you're doing. It shows that glib, smug fellow is not to be trusted any more than his belt line. And when a witness crumbles that you know was a liar and who might well have caused a conviction, I think that is satisfaction personified. Now, to get there, you have to be what I was in law school. I did not attend classes. I was a great crammer. Every trial lawyer I have met who was worth his salt was a crammer. The night before the trial, he would assimilate the file into his brain. And then when he had a witness on the stand, he never took his eyes off the witness. He never looked at a note. He remembered what it was that was important. And pretty soon the witness is intimidated because he's saying to himself, this lawyer knows my testimony better than I do. I could be in trouble if I try to stray. Once you have imposed that kind of discipline, It seems to me, at least, that you can put a nose in the ring of the pig and lead him around the courtroom.
My wife's an attorney. We met in law school. We practiced together. Our daughter just finished her first year Lee at USC, and she's doing fantastic. Guess what? She's on the mock trial team, which is a very big deal for a first year student. What advice do you have for our daughter and her friends, their first year students, over the next 2 years in law school? What should they be focusing on? What should they be centering their attention on with respect to if they want to be trial lawyers?
Well, if they want to be trial lawyers, now I can tailor my advice narrowly because that is a special breed.
Yes.
I think that they are on top of the profession because what they do tends to regulate what settlements are offered and paid at a lower echelon because 95% of all cases avoid trial and eventually go to settlement. I would suggest to these youngsters, as I have in many lectures and do in the book I wrote about cross-examination, number one, get a good command of the King's English. People don't teach that anymore. They don't do it anymore. I hear lawyers say, like, and you know, and I cringe. These are people that are supposed to be able to tell a jury what's going on. Number two, advance your memory. It is so much easier than people think. I mean, everybody says, oh, Lee, how do you remember all this stuff? And I say, how did you pass the bar? You let you take notes into the bar exam. You crammed it home. You remembered it. You regurgitated. That is the trial lawyer's life. Learn to do it well. And number three, and this comes as a surprise to some because they figure trial lawyers is these guys with a bullwhip and they're cracking it and cowering witnesses and beating up on little old ladies. Number three, be a nice person. Juries quickly figure out whether you're a nice person. And I have a thumb rule. If the jury likes a criminal defendant, they'll acquit him. If they like his lawyer but are unsure about him, they'll try to acquit him. And if they don't like either of them, sayonara.
There's something about being a nice person in a courtroom. There's something about showing your human side, Lee, to a jury. And one of the things that I really stress with young lawyers who want to become better trial lawyers is I stress to them about learning people skills, about using those soft skills, about making it all about the jury, asking open-ended questions, right? And connecting with them, building rapport. Because like you just said, and I've never articulated it that way, but I'm going to, and I'm going to give you credit for it. If the jury likes your client, if the jury likes you, you're 10 steps ahead in the game, right? All else being equal. How about connecting with a trial judge? Any thoughts or tips for young trial lawyers with connecting with the judge?
Well, that is extremely important. Nothing in this world is more likely to produce a just result than two good trial lawyers working their hearts out in front of a good trial judge. Trial judges come in all kinds of flavors and forms. I have had the good fortune over 60 something years of being in court to hit some wonderful trial judges. They have been right down the middle. They have stood tall and they have been courageous in their rulings and also knowledgeable. That's a wonderful package. Sometimes I know I got these judges because the case was front page and the Supreme Court of the state didn't want anybody to look like a fool, so they put a good judge on it. To me, that's the best news in the world. We have a lot of judges out there, I shouldn't say a lot, a number, who really shouldn't be on the bench. They don't have the temperament, they haven't done the homework, they haven't had the skills. Thank goodness, at least in my case, those are few, although when one hits you, they hit you pretty hard. So go into every trial with the presumption the judge is a good person, knows what he or she is doing, and would treat you fairly. Do not ever ignore signals that that is not the case, and you better keep your hands high and you better counterpunch when the judge really leans on you, because that a courageous lawyer can often back down a judge who is being a bully.
You said look for signals, and that's so important. I always try to make it easy for the judge to rule in our favor. I always try to make it easy for the judge. And I mean, you try to be prepared. You have your witnesses ready to go. Don't create unnecessary issues in a courtroom where, Lee, out here in California, it's hard to find an open courtroom. I mean, everyone's waiting to show up and try a case, and then there's 8 other cases in front of us. And so I try to tell young lawyers, get your ducks in a row so that when it's time, you're ready to go. And you put on a nice, smooth case. It helps the judge, it helps opposing counsel, it helps your jury, and it helps the court staff. And I think that's invaluable information. We have a lot of entrepreneurs that watch this show. They're not lawyers, Lee, but they are engaging with the news media. And I don't know too many lawyers over his or her career who has engaged as often as you have with the news media, whether it's on the fly out in the front steps of a courthouse on a big case, whether it's Time Magazine, whether it's CNN, whatever it might be. You've done a heck of a lot of interviews, and you've engaged with the news media more so than most. Any tips, any advice for business owners and entrepreneurs who are starting their careers and they're finding themselves, on the other end of a microphone or the receiving end of a news camera when dealing with the media? What are your tips?
Well, I have several. First of all, watch out, because media representatives come to the interview often with an attitude. And even if they write a lovely story about you, their editors will say, look, we're not in the business of creating an F. Lee Bailey fan club. Let's get some chop in here. Let's get some negative stuff. That has recurred over and over again. So when somebody walked into my office for an interview, I say, I'd like a statement of your intentions. I'm not looking for a fluff job, but I'm not looking for a hatchet job. So what do you have in mind to ultimately publish? Well, cross-examination is something they haven't been educated for, and some of the answers I've gotten would tickle your fancy. I had to learn to deal with the media for this reason. There are 2 standards, just as I have one for guilt and one for innocence. I have one for ordinary defendants and one for celebrities. Simpson was in the latter category, and in those cases, it is not enough to establish a reasonable doubt and get an acquittal, as his case shows more than any other in history. You really need to show the public your client didn't do it. In this case, we had no chance. The courtroom was so sloppily run, and I've got to tell you, California is not a good place to try cases if you're in a hurry. All the ones I've tried out there took 3 times as long as they in most other states. Indeed, I'll burden you with an anecdote. There is a judge in Denver, I think he's senior now or retired, named Richard Mitch. He was famous as a guy who came to court with a 10-gallon hat, cowboy boots, and he tried and sentenced to death Timothy McVeigh, who blew up the Oklahoma City building and killed a bunch of women and children. I had lunch with him right after the OJ verdict. We was both speaking in Denver to some group. And I said, Judge, where were you when we needed you? And he kind of smiled. And I said, seriously, if you had been presiding in the Simpson case, how long would it have been before you put the first lawyer in jail for having diarrhea of the mouth? He said 3 weeks. That's my answer to the California litigation problem. It's a shame because cases need to be tried more quickly, more crisply, and more concisely, and they would cost an awful lot less. Right now, the cost of litigation of any case is beyond the budget of almost every American.
What's your most memorable experience as a trial lawyer? Not necessarily the most famous case, just the most memorable experience for you.
I guess that would have to be in the retrial of Dr. Sam Sheppard. The coroner had said in the first trial that he saw the imprint of a medical instrument on the pillow of the deceased, which was covered with blood. That pointed directly at the defendant, who was a medical doctor and a surgeon. He never described what the instrument was. The lawyer never asked him. Now we come up on the second trial. I have him on the witness stand. He knows he's a cooked goose. I said, Dr. Gerber, have you lectured all over the world about how you helped convict Sam Sheppard with your opinion on the medical instrument? He said, not all over the world. I said, in 20 countries? He said, maybe 10. I said, Dr. Gerber, what was the instrument? He said, I don't know. I said, tell the jury where you have looked to find an instrument that would fit what I believe is obviously a Rorschach fold in the pillow. He said, I've looked all over the world. That's the high point.
And it's those experiences that a lot of us have never heard about, never read about. I know you have a book, The Defense Never Rests, which is available on Amazon. But did you share that story in your book?
That's in the book, and it's also in one of the cross-examinations in my book, Excellence in Cross-Examination.
Excellence in cross-examination, which is that's where I've won and lost one of my cases. I haven't lost too many cases, Lee, but the ones that I've won has been cross-examination, opening statement, and closing argument. Quick question from Jenny Q. Jenny Q's got a fantastic internet talk show, variety talk show on live stream. And her question for you, Lee, is what is the most relevant life lesson we as a society can learn from the OJ trial?
I think there are two. Number one, do not be hornswoggled by what the media are promising. They said the case was built on a mountain of evidence. That mountain turned out to be an anthill. People like you almost blew my phone up the day the government rested and said, rest your case. They haven't proven anything because they were trial lawyers and could assess the evidence without all of the emotion. The second thing is that when you ruin a person's life by putting the imprimatur of guilt gratuitously, uninformed in most cases, after a jury has worked for 9 months and found him summarily not guilty, you ought to go look in the mirror and say, who in the world are you? Because this guy went through Hades, emerged finally, an American turned on him, insulted the jury. I have almost no patience for the villains in that case, but I'm not the world's most patient man.
I've learned how to become more patient over time, Lee. I'll tell you that, and my beautiful bride and partner will tell you that's the case. Well, let me ask you a question, and I don't want to put you on the spot, and you don't have to answer it if you're not comfortable with answering it, but I'm reading between the lines from what you're saying that you do not believe that Mr. Simpson committed the murders. If that's the case, do you have an opinion as to who did or why, what the situation was?
Yes, I do. It is set forth in detail on my website, BaileyandElliott.com, all lowercase, no punctuation. It's a 17,000 word summary of how the OJ case began, how I put together the defense, how we executed the defense, what surprises we got along the way, like the Furman tapes, and how we assimilated those into the case, but much more important, why we were shut down because Judge Ito got rid of so many jurors, we almost ran out. Now, as you know, in California, in a non-capital case, criminal, you can go with as few as 6 if both sides agree. We went to the judge. We said, we're going to lose more jurors. One is 73. One's having chest pains. We want to go with as low as 6. Marcia Clark said, oh, no, I want a mistrial. Now, she knew she'd lost the case. She hasn't been very honest about that since, but nothing much good has happened to her either.
Quick, I'd love to hear your thoughts, the insider tips on when Simpson was asked to put on the gloves. I mean,
Okay.
as a trial lawyer, I'm like, you've got to be kidding me. Tell us a little bit more about that fiasco.
I'll resurrect that for you. But first, I want to say that any one of your listeners who takes the time and trouble to read that piece, which is two memos, one before the trial, predicting what would happen, one after the trial, explaining why it happened. They are free to call me, debate, contest, or ridicule if they'd like to try any part of that memo they think is suspect. Now, the glove, the mighty glove. First of all, Mark Furman told us what this case was about in a recording, and I published this in a couple of places. It is just coming out again as a supplement to Excellence in Cross. But his statement was in response to Miss McKinney's question. Now that Newsweek and New Yorker have shown that you're a racist, will they throw you out of the case? He said, no. This is a case about a glove. Without me, the glove doesn't get into evidence and the case goes bye-bye. They won't throw me out of anything. Mark Furman knew 3 months before the lab did that Nicole and Ronald's blood were on that glove. Couldn't have known that unless he picked it up at the scene and brought it there. Number one, when Chris Darden was trying the case, when I was in the courtroom, he sat next to me. He would give me a slip of paper after each argument, cross-examination, whatever he did, and ask me for a score and suggest a straight A. And I usually handed him back a C minus, and his face would be unhappy. But in any event, I learned he was a hothead. The glove was sitting on the evidence table. I looked at it. I said, my Lord, that won't fit, OJ. I tried it on. I've got a size 9 hand, Exhibit A. OJ can wrap his finger around a football so he never fumbled because his hands are huge. So I went over to Darden, and quite apart from what was shown on the FX thing, the people against OJ Simpson, there was no agreement among counsel. I went over to Darden on my own during a recess, and I said, and your listeners will pardon me for quoting the exact words, but I put them in the book too. I said, Chris, you're a good shit, but you've got the balls of a stud field mouse. And he went, and I said, Chris, that glove won't fit, OJ. You don't ask him to try it on. I will. Wasn't even my witness. I was bluffing. He took the bait as Judge Ito came back to the courtroom, went up his little steps so he could get on the bench. Darden rushed him, and he said, Your Honor, Mr. Bailey has told me something, and I want Simpson to try on the glove. The rest is history. It is one of the biggest blunders ever. But at the end of the day, that didn't sell the jury, although it certainly didn't hurt.
You know, it's interesting. There's so much that happens during a trial that the public never sees or hear about, even if you're sitting in the courtroom. And what you just shared, going over and making those comments to Darden, I mean, you know, that got him to take the next step that you wanted him to take. As lawyers, you know,
same thing. There's nothing like provoking your opponent in a courtroom in order to get him to step into the doo-doo.
Oh, absolutely. And a lot of times what we'll do is file motions on issues that we really don't care about, and it gets everybody busy overlooking this direction when in fact you're going this direction. And I'm glad you shared that story, Lee, with the audience, because that's the way things do work behind the scenes in a courtroom. Not only during the trial, Lee, but as you well know, before trial, during your meetings, during your pretrial conferences. You know, things are said. It's a poker game, and you just better have the facts to back it up. That's fascinating.
I would like
Go ahead.
to leave with young lawyers.
Please.
And it was taught to me by an FAA lawyer many, many years ago. It's called a pocket brief. When you can see a contested issue of evidentiary nature coming up in a trial, whether something should be admitted or excluded and so forth, where the trial judges have tremendous discretion. As you know, appealing evidentiary issues, unless they are flaming, generally doesn't bear much fruit. But trial judges are human too. If you've got the aces in the deck, they're going to tend to bet on your hand. So if you draw in advance a 1 page, no more, memorandum of law on that issue, and it does come up, and a lot of these, like the rabbits and the hats, never get used. If it does come up and you say, Your Honor, I believe you should rule in my favor, and here's why. Number one, the other side does not have a pocket memo. Number two, there isn't time for them to go create one. As you hand them a copy, they barely have time to read it, and there's no discovery and that sort of thing. And the judge takes a look and he said, well, if I rule this way, I can't be a fool because I've got authority here to cite. I won almost every one of those battles after I learned to have my staff make me a whole bunch of pocket briefs and to keep them right in this pocket. Yes, for those who take the rabbit out of the hat maxim to heart, bear in mind, the guy who actually pulls the rabbit out of the hat on stage has done a lot of work to get to that point. There is no free lunch.
Well, I'm honored and proud to tell you, Lee, that that's my approach too. I don't bring every pretrial motion. I don't let the other side know every single issue I'm going to be arguing during the middle of a trial, and I'm ready with a 1 or 2 page memorandum of points and authorities, like you just said, and it works really, really well. But here's the thing. It's not pulling rabbits out of our hats. What it is it's working our asses off and preparing harder than the other guy or gal. Whether you want to admit it or not, that's what I'm listening to you telling our audience is get your act together, practice the 6 Ps, prior preparation prevents piss poor performance, and go in and do your job. And if you do your job oftentimes in a way where you're showing your human side and you're connecting with the jury, good things will happen, especially if they like your client and especially if they like you. Lee, this has been a fantastic show. I really appreciate your time. Lee, thank you very much. Everyone in the audience, thanks for joining us today on the Show Live. Have a great day and always make each day your masterpiece. Bye-bye.